Turning to the third panelist, having heard from two preeminent lawyers, we're now going to hear from somebody in the banking sector. His name is Robin Willing. Robin is a senior sustainability officer at NIBC Bank, based in Amsterdam. And at NIBC Bank, he has overall responsibility for sustainability, ESG, and corporate social responsibility. Robin has developed NIBC's sustainable finance framework. He is also involved in sustainability and ethics policy development and implementation, including the bank's code of conduct, as well as ESG assessments, due diligence, and monitoring, including human rights due diligence. So Robin's insights are going to be especially welcome. His presentation will focus on human rights in corporate lending, including his explanation of responsible ship recycling standards, as well as the International Responsible Business Conduct Agreement. So with that introduction, I'll hand the floor to Robin.
Thanks, John. I'm Robin Willing. I'm responsible for sustainability at NIBC. I'm actually the head of sustainability, so the title, depending on how you want to look at it. It's really an honor to be one of the panelists on this webinar and to speak with all of you today. I'd like to compliment David and the team at Human Rights at Sea and the team at Shearman and Sterling on their efforts to date on the white paper, and it really goes in line with some of our own thinking on human rights and the need to create ecosystems which fully support human rights in all sectors, to be honest. First, a brief introduction about NIBC itself. We're a mid-sized retail and commercial bank, actually based in The Hague in the Netherlands. It was nice hearing the panelists earlier because we're located directly across the street. Our headquarters is from the Peace Palace in The Hague, where the various developments have been taking place on human rights recently. We were established in 1945, so this is actually our 75th anniversary year to help build the Dutch economy after World War II. Currently, we have operations in the Netherlands, Germany, Belgium, and the UK. And within our corporate banking unit, we focus on a limited number of sectors, but these include shipping and offshore energy services. So we really are involved in maritime activities. Within that, we perform human rights due diligence for 100% of our corporate loans and investments. I'm quite involved in that effort, and my colleagues as well, and I'll explain a little bit further. It probably helps a bit when you see or hear about it a bit more in practice. Among the core human rights related policy commitments of NIBC are the Universal Declaration of Human Rights, the OECD guidelines, the UN guiding principles, ILO core conventions. On the screen, you see a big piece that you would both see on the Human Rights at Sea website, but also in our human rights policy. So I give you a reference directly to our own policies that we have embedded human rights at sea because we feel it's so important and so material to the sectors that we're operating in. We're one of the founding members of what are called the Responsible Ship Recycling Standards. This is a focus on supply chains in the maritime sector. Currently, 9 banks are involved. Their logos are up on the screen so you can see everybody that's been involved. But we started this initiative together with ABN AMRO and ING with a view towards strengthening human rights and environmental standards within the full shipping value chain. And we're focused, it started by focusing on one end of the value chain, and I'll explain that. But importantly, it was developed with strong cooperation with our clients and ship owners, with NGOs, with national authorities and other stakeholders. The standards themselves embed core commitments in financial contracts, which is very interesting, I think, for the discussion today and for this group. These include obtaining and maintaining an inventory of hazardous materials for the vessels that we finance. Usually this is to be achieved at the next dry dock or within a year, in the case, or for refinancing of existing ships. So that it depends a little bit on what and when. We give a bit of flexibility there so owners can live up to it. Clients are encouraged to extend this to all or at least part of their fleet in addition to the ship we finance. We require dismantling according to the Hong Kong Convention and/or EU standards. Dismantling according to the Hong Kong Conventions and the EU regulations. Probably addressing one of the points from the prior presentation, we require this regardless of the flag of the vessel. So even for non-EU flagged vessels, we require compliance with these standards, and we lean much more strongly towards the EU regulations than purely the Hong Kong Convention for a lot of different reasons. We also avoid or ask the ship owners to avoid irresponsible practices, which are often linked to cash buyers, for those familiar with that. And beyond that, to exemplify transparency in several different ways, such as to develop a company policy in regard to responsible dismantling, publish policies or policy statements on their website, preferably in a way that's really publicly available, and to promote better practices within the shipping sector. And I think this is quite important for what we're talking about today. We are also involved as one of the banks in the International Responsible Business Conduct Agreement of the Dutch banking sector. This was an agreement that we signed 3 years ago. Most of the large Dutch banks are signatories of this, so ABN AMRO, ING, Rabobank, etc. There's a focus within the Dutch banking agreement, as we call it, on human rights responsibilities as defined by the main international standards, particularly the OECD guidelines and the UN guiding principles on business and human rights were a focus point within this. And within the UN guiding principles, particularly the UNGP reporting framework, so to be more transparent about what's happening in regard to our financings and investments. Other parties to the agreement included civil society organizations like Oxfam and Amnesty, trade unions, national authorities like the Ministry of Foreign Affairs and the Ministry of Finance, and the Socioeconomic Board, or SARE, here in the Netherlands. There were several working groups within this agreement that were created, including one on enabling remediation. And we've shared this work in the Enabling Remediation Working Group and the other working groups with the OECD and the UN Office of the High Commissioner on Human Rights. The final report of the agreement will be published shortly, I think in the coming few weeks. So you can check on the SARE website actually for this information, or if anyone wants to contact me, I can give you the links. The agreement itself and the paper on enabling remedy, probably just a few things to mention there, because it covers a lot of the things that others have already mentioned, but it recognizes the bank's responsibility and business responsibility to establish or participate in effective operational level grievance mechanisms. And I think that's really important for this discussion. In our discussions, we recognize that industry sector mechanisms are one of these and complement judicial and non-judicial processes, company mechanisms and other state mechanisms. They play a variety of different roles, including providing effective remedy to stakeholders, serving as a feedback loop as part of ongoing company due diligence by identifying impacts, potentially ones that we don't see, as opposed to the risks, and as an indication of the effectiveness of the prevention and mitigation measures that are often part of corporate governance. Importantly, these holding companies accountable for the commitments they make. So I think that's a key part of what our role is and how we're trying to carry it out. We view effectiveness as being legitimate, accessible, predictable, equitable, transparent, rights compatible, a source of continuous learning. The banks actually set up their own learning mechanism, which is hosted at the Dutch Banking Association. And it's based on continuous dialogue. One of the things that I think is a learning is for us, processes become most effective when they're truly stakeholder driven, informed and guided by the different perspectives that different stakeholders have, and also the desired outcomes of those that have been adversely affected. The paper also recognizes the need to build a broad grievance and remedy ecosystem. And this maybe speaks to John's point about there is no one silver bullet, but instead we really need an ecosystem where there are different actors playing different but complementary roles, different arbitration mechanisms or grievance mechanisms which can help to address these, and preferably the parties that are aggrieved can choose the one that's closest to them or which they believe is most transparent or effective for them. Action is required by all parties that have caused or contributed to or are directly linked to the harm. Typically banks fall into that latter category of directly linked as financiers, and therefore are compelled to actually help bring parties to the table if necessary. When negative impacts occur, all of us, every actor that's within the value chain and connected to it, have some kind of responsibility to take action to address those impacts. Affected stakeholders may in many cases need different forms of support in order to access and participate effectively. And we recognize that. Businesses connected to the impact, governments, civil society organizations, trade unions, all may have different complementary and supporting roles in this. We heard a few of them earlier today, but I think it's important to recognize that all actors have a role in this and to enable remedy and practice. So a robust grievance infrastructure really includes company level, state-based and sectoral mechanisms. Our main role as banks is an influencing role in using our leverage to encourage clients to cooperate in good faith, hopefully addressing some of those transparency issues with third-party processes and to seek a consensual resolution with affected parties. That's what I wanted to speak to, because I think it's really important to mention where banks are on this. I think this shows that we're interested in building up our role in terms of helping to bring parties to the table and really begin to address the concerns that people are facing when they have been impacted. Importantly, I think it is a complementary role to what other parties have mentioned earlier today, and I think we can achieve this in different ways, whether it's through building more detailed requirements into agreements like the responsible ship recycling standards. We are openly talking about that with NGOs and other third parties, how we might build in certain human rights standards as part of the standards, and therefore included in financial agreements, thereby enabling other parties that are involved in the value chain to bring things forward a little bit more easily, because then it is a legal obligation and it's hard to ignore if it's in a financial agreement. But there are a number of ways that this can be taken forward. With that, I think I'll turn it back over to John.
Robin, thank you very much for your presentation. I very much liked your, among other things, the use of the word ecosystem. I thought it sort of conveyed the complexity and the interconnectedness of the system, or which the network in which, you know, this idea, this concept of human rights and sea abuses arbitration will fit into. And I think it's recognized in the paper itself that there is no silver bullet, as you alluded to, and the presence of different actors performing what you said were complementary roles. And I thought that very much from a banking perspective, a non-legal perspective, complemented what Emmanuel and James spoke to in their presentations as well. And obviously, I'm sure everybody's encouraged to hear that the banks are looking at the inclusion of human rights standards in finance agreements. And I think that's probably an exciting area, and probably an area, going back to Manuel's comments earlier, of procuring the necessary consent to making such a system work.